Today, I would like to present to you the issues related to the SENT and RMPD systems. First, I will briefly focus on the differences between these systems and the legal acts regulating them. And then, I will present in detail the procedure, the course of proceedings, and above all, the most important differences between the proceedings. I will also present two very important issues: the transmission of geolocation data and the obligation to present the vehicle based on the inspection directive. I will also discuss the most common mistakes encountered in practice that lead to the imposition of a financial penalty. The SENT system is not the same as RMPD. SENT is a system for monitoring road and rail transport of goods and the trade in heating fuels. RMPD, the Register of International Road Transport, is the working name of the forms adopted for notifications in the SENT system dedicated to foreign entities carrying out road transport, as referred to in Article 28b of the Act of 6 September 2001 on road transport. RMPD notifications to the Register of International Road Transport apply to foreign road carriers and do not apply to entities with their registered office in Poland. The most important difference is that SENT notifications are required due to the goods and RMPD notifications are required due to the entity. In both cases, transport monitoring is carried out using forms available on the PUESC platform. SENT and RMPD are obligations regulated by two different legal acts, two separate statutes. SENT is an act of 9 March 2017 on the monitoring system for road and rail transport of goods and trade of heating fuels, and RMPD is based on the Road Transport Act. It's very important that SENT and RMPD notifications do not replace one another. If a foreign carrier transports goods subject to SENT monitoring, two separate notifications are required: one SENT notification and one RMPD notification. Transport operations subject to RMPD notification include all transports carried out by foreign carriers, regardless of the type of goods transported. As of 1st November 2024, the notification obligation has covered all transport of goods carried out in Poland by foreign entities that do not have their registered office in a member state of the European Union or in Switzerland, Iceland, Liechtenstein, or Norway. As of 1st January 2025, monitoring has also been extended to certain transport operations carried out by carriers from the European Union and EEA countries. Proceedings concerning the imposition of monetary penalties for violations of the SENT and RMPD system may be divided into administrative proceedings conducted by tax authorities, the heads of customs and fiscal offices, and subsequently the directors of revenue administrative chambers, and administrative court proceedings conducted by administrative courts. The entire process begins with an inspection report, most often carried out as a roadside check. If during a roadside inspection the inspectors identify violations, they will be described in the inspection report. The report should be signed by the inspectors and the driver. The driver has the right to submit comments or objections to the report, including objections regarding the procedure or the way in which the inspection was conducted. One copy of the inspection report is given to the driver. If a violation is identified for which the driver may be fined, the driver may be punished with a fine ranging from 5,000 zł to 7,500 zł. If the company or the driver does not agree with the identified violations, they may submit comments to the report on the third page of the report in point 10. In such a situation, the driver may also refuse to accept the fine. In the case of foreign carriers, if the inspectors identify mistakes in SENT declaration, they will collect a security deposit in an amount corresponding to the anticipated financial penalty. Payment of the deposit is a condition for releasing the vehicle and goods for further travel. If the deposit is not paid, the vehicle, together with its goods, will be directed to or removed to a place indicated by the officers. The deposit is collected either in cash against the receipt or in a cashless form if the collecting officer has the appropriate device to authorize the transaction. Financial penalties apply not only to transport inspected during road checks, but also to transport registered in the SENT system where irregularities are identified during a registry review. A repeated mistake in many notifications can result in numerous proceedings and very high penalties. It is not unusual for a carrier to face, for example, 50 proceedings, each imposing a 10,000 zloty penalty, leading to a total of 500,000 zloty. In cases of repeated failure to appear for inspection, there may be, for example, 40 proceedings, each imposing a 20,000 zloty penalty, which may result in total penalties of 800,000 zloty. Notices initiating proceedings are often delivered many months or even years after the irregularities occur. This makes it more difficult to identify and correct errors and leads to repeated violations by unaware companies. An example of a request to submit a statement issued in connection with violations: failure to present a means of transport for inspection under the so-called inspection directive, identified by the authority in the course of analyzing data in the Rejestr during the review of camera footage. The transport during which the violation occurred was carried out in July 2023. The request was issued only in March 2024, so more than 6 months after the transport. In the case of carriers having their registered office in Poland, the penalty is payable after the completion of administrative proceedings. No deposit is collected from them. If a violation is identified during the inspection, the head of the Customs and Tax Office initiates ex officio proceedings to impose a financial penalty. The head issues a notice of initiation of administrative proceedings in this matter, which is sent to the entrepreneur. After receiving the notice, the entrepreneur has the right to present their position, submit explanations, and file motions. In support of its position, the company may indicate or attach evidence. Before issuing a decision, the head of the Customs and Tax Office should grant the party a period of at least 7 days to comment on the collected evidence. The statement should be submitted in writing. Failure to submit explanations within the time limit set by the authority does not result in the loss of the right to submit them later. They may be submitted until the conclusion of proceedings before the authority of second instance. What is really important that in the case of carriers who do not have a place of residence or habitual stay or a registered office in the Republic of Poland, another member state of the European Union, the Swiss Confederation, or a member state of the European Free Trade Association with regard to proceedings concerning violations of RMPD obligations, it is necessary at this stage to appoint an agent for service of documents in Poland. In such cases, the authority serves only the first document in the matter, so the notice of initiation of proceedings, which informs the party of the obligation to appoint an agent for service of documents in Poland, and that, if such an agent is not appointed, further documents will be placed in the case file and will be deemed to have been served. This obligation does not apply to proceedings conducted under the SENT Act. In such proceedings, all documents are served on all parties, including carriers having their registered office, for example, in Ukraine or Turkey. The head of the Customs and Fiscal Office issues a decision by which he imposes a penalty, discontinues the proceedings, or refrains from imposing a penalty. Waiver of the imposition of a penalty. In SENT cases, the regulations expressly allow the authorities to waive the imposition of a monetary penalty. A waiver differs from the discontinuation of proceedings. In the case of discontinuation, the authority finds that the carrier did not commit an infringement, whereas in the case of a waiver of the penalty, the authority acknowledges that the infringement occurred, but nevertheless decides not to impose a penalty. If a security deposit was previously collected, it is subject to refund. The authority may refrain from imposing a financial penalty due to an important public interest or an important interest of the carrier. The important interest of the carrier applies to situation in which the carrier is in a very poor financial condition. In the case of RMPD, the regulations do not provide for a comparable mechanism allowing for a waiver of the imposition of a penalty. The Road Transport Act provides only for the possibility of discontinuing the proceedings where the carrier had no influence over the occurrence of the infringement and the event that caused it was unforeseeable. In practice, this ground is very difficult to invoke. Is it possible to reduce the amount of the monetary penalty? The RMPD regulations, similarly to the SENT regulations, provide for penalties imposed in fixed amounts. This means that a specific infringement is punishable by a penalty of a precisely defined amount, for example 10,000 zloty or 12,000 zloty, regardless of whether the infringement resulted from a minor error or was of a more serious nature. Such penalties are not subject to mitigation or adjustment. Although these penalties may appear disproportionate, they are currently being applied in practice. Consequently, where a penalty of 10,000 zloty is prescribed for a given infringement, the authority may not impose a lower penalty, such as 2,000 zloty or 4,000 zloty, on the grounds that such a reduced amount would be sufficient. The system is based on a strict liability. The only relevant factor is that the violation took place. Since the regulations do not provide for the possibility of reducing the penalty, and the waiver of its imposition is disputable, does this mean that carriers are always exposed to the risk of a penalty and that it cannot be avoided? Not necessarily. There are situations in which it is possible to defend oneself against the penalty by presenting arguments that are favorable in the given circumstances. Examples include cases related to the unavailability or malfunction of the monitoring system itself, which may sometimes lead to a temporary difficulties in updating notifications or transmitting the vehicle's geolocation data. In some cases, situations in which carriers are accused of incorrectly completing data in an RMPD notification also require more in-depth verification. It happens that inspectors identify an infringement on the basis of documents, but after the matter is clarified and the documentation is completed, it turns out that no infringement actually occurred. Yet another category of cases includes those involving various legal doubts. These doubts may concern the proper interpretation of regulations and the scope of obligations arising from the Act. For example, it may turn out that, contrary to the initial findings in the inspection report, a particular carriage was not subject to RMPD notification at all. There is a possibility to lodge an appeal against the decision imposing a monetary penalty, both under the SENT Act and under the Road Transport Act. However, there is a strict time limit, the failure to meet which will result in the appeal being declared inadmissible. It's 14 days from the date of service of the decision. The appeal should include an indication of the decision appealed against, the authority that issued it, the date of issuance and the decision reference number, the grounds of appeal, a request for amendment or annulment of the decision, a statement of reasons supporting the grounds of appeal, and the appellant's signature. After the party files an appeal, the head of the Customs and Tax Office forwards the appeal together with the case files and the response to the appeal of the Director of the Tax Administrating Chamber. In the course of the appeal proceedings, the party may submit explanations and present evidence. The appellate authority not only examines the allegations raised in the appeal, but in effect re-examines the entire case. After examining the appeal, the Director of the Tax Administrating Chamber issues a decision in which they either uphold the contested decision of the head of the Customs and Tax Office, repeal it and decide on the merits of the case or discontinue the proceedings, repeal the decision of the head and refer the case back for reconsideration. Proceedings before the head of the Customs and Tax Office and the Director of the Tax Administrating Chamber are not subject to any court or stamp costs. After the conclusion of proceedings before the authorities, the decision becomes final, and if a penalty has been imposed, the company must pay it. Filing a complaint does not suspend the obligation to pay the penalty. Its payment may be suspended by the court upon the party's request included in the complaint. This obligation to pay the penalty does not, of course, apply to foreign carriers from whom a security deposit was collected during a roadside inspection as an advance toward the future monetary penalty. The decision of the authority of second instance may be challenged by way of a complaint filed with the Voivodeship administrative courts. There is also a strict limit, 30 days from the date of service of the decision of the Director of the Tax Administrating Chamber. The complaint must include the allegations against the decision, the claims, request, and the statement of reasons. The complaint is also subject to a court fee. The amount of the court fee depends on the amount of the penalty. In the case of a penalty of up to 10,000 zloty, it's 4% of the penalty, but not less than 100 zloty. In the case of a penalty of over 10,000 zloty, up to 50,000 zloty, it's 3% of the penalty, but not less than 400 zloty. In the case of a penalty of over 50,000 zloty, up to 100,000 zloty, it's 2% of the penalty, but not less than 1,500 zloty. And in the case of a penalty over 100,000 zloty, it's 1% of the penalty, but not less than 2,000 zloty. The Voivodeship Administrative Court may request a sworn translation of an extract from the Foreign Entrepreneurs Register to ensure that the person granting the power of attorney is authorized to represent the entity. The cost of the sworn translation will range from several dozen to several hundred zloty, depending on the number of pages of the document. Failure to comply with the court's request in this regard will result in the dismissal of the complaint. In the course of court administrative proceedings, the party, as a rule, may not present new evidence except for documentary evidence, provided that presenting such evidence before the authorities was not possible. Taking documentary evidence before the Voivodeship Administrative Court is an absolute exception. Therefore, all evidence should be presented at the stage of proceedings before the authorities. The administrative court reviews the legality of the decisions issued by the authorities, and the proceedings before it are really formalized. Witnesses are not examined before the administrative court. The Voivodeship Administrative Court dismisses the complaint when it does not accept the company's arguments or repeals the contested decision in whole or in a part when it accepts the company's arguments. The administrative court may also declare the contested decision null and void. If the court upholds the complaint, it prepares the written justification of the judgment ex officio and serves this on the party. If the Voivodeship Administrative Court does not uphold the complaint and dismisses it, the written justification of the judgment is prepared only upon the party's request. Such a request must be submitted in writing within 7 days from the date of announcement of the judgment. It should be noted that the time limit for submitting a request for justification runs from the date of announcement of the judgment, regardless of whether the party was present. The request for justification is subject to a fixed fee of 100 zloty. Submitting a request for justification is a prerequisite for challenging the judgment by the company. If the judgment of the Voivodeship Administrative Court is unfavorable, it may be appealed to the Supreme Administrative Court. There is also a strict time limit, 30 days from the date of service of the judgment, together with the statement of reasons. The complaint must include the allegations against the decision, the requested and the statement of reasons. It must be prepared by a Polish advocate or a legal counsel. The complaint is also subject to a court fee. The amount of the court fee depends on the amount of the penalty. The fee for a cassation appeal is half of the fee for a complaint to the Voivodeship Administrative Court, but not less than 100 zloty. The Supreme Administrative Court dismisses the cassation complaint if it does not accept the arguments of the party who filed it. If the cassation complaint is found to be justified and the judgment of the Voivodeship Administrative Court is repealed, the Supreme Administrative Court may also repeal the decisions of the authorities and even discontinue the proceedings concerning the imposition of the penalty. In the event of the Voivodeship Administrative Court's judgment, or the authority's decision being set aside without discontinuing the proceedings, the case is returned to the authorities for resolution in accordance with the court's guidelines. It is also important to consider the risk arising from the obligation to reimburse the costs of the authority's legal counsel if the carrier is unsuccessful in proceedings before the Supreme Administrative Court. In such circumstances, the carrier may be required to bear those costs, which are calculated based on the amount of the imposed monetary penalty and may reach several thousand zloty. On the other hand, if the carrier wins the case, the authority is obliged to reimburse all costs incurred by the carrier. That concludes the discussion of administrative and administrative court proceedings. I hope I have provided a clear overview of how the procedure is conducted in Poland. Now, I would like to tell you a bit about the vehicle's GPS data and the inspection directive, which in practice are often associated with irregularities. One of the basic obligations of carriers is to ensure the transmission of up to date GPS data of the means of transport to the monitoring system throughout the entire transport route within the territory of the country. The regulations require not only the recording of the route by a GPS tracking device installed in the vehicle, but also the transmission of current GPS data of the means of transport to the monitoring system on a continuous basis. A common mistake made by road carriers encountering SENT or RMPD transports for the first time, particularly those using external GPS tracking systems, is that the data is recorded but not transmitted on a continuous basis. GPS data must be transmitted throughout the entire transport route within the territory of the country. In practice, there may be interruptions in the transmission of location data to the monitoring system that are not always recognized by carriers, resulting, for example, from technical failures, GPS signal interference, or lack of internet access. Such situations, however, do not exempt carriers from liability. Failure to transmit current GPS data to the monitoring system is subject to a financial penalty of 10,000 zloty. The SENT Act provides for the so-called inspection directive. This constitutes an obligation on the carrier to present the means of transport together with the goods covered by the SENT notification for inspection. In accordance with the request for inspection, the carrier is required to present the means of transport on the date of completion of the transport of the goods, at the place of delivery of the goods, or at the customs and tax office branch located closest to the place where the transport is completed within the territory of the country, in the case of road transport, or at the place indicated in the notifications, in the case of rail transport. No analogous obligation applies to RMPD notifications. The Road Transport Act does not provide for the application of Article 12A of the SENT Act to such notifications. Failure to comply with the inspection directive is subject to a financial penalty of 20,000 zloty. Most common violations in practice: typos and other accidental errors in the vehicle registration number, consignment no number, address of the entrepreneur involved in the transport, etc. Errors in GPS data transmission, for example, recording location data but failing to send it to SendGeo, submitting the notifications or activating the GPS tracker shortly after the transport has started instead of before it begins, changing the planned border crossing point, and failing to update this information in the notification. Other errors concerning the transport's departure and arrival points, such as entering the correct locations in the wrong reversed form fields. Other errors made when completing the notification forms include, for example, the country of vehicle registration, the country of issuance of the permit, and the mixing up of consignment notes when a transport operation is carried out on the basis of several CMRs, the date of entry into or exit from the country's territory, and the failure to update this information in the notification, failure to enter the trailer registration number, changing the license, permit, or certificate number while continuing to enter an outdated number, entering the number of the license extract copy instead of the correct license number, and expiry of the reference number, and failure to submit a new notification within the required time limit. It is important to be aware that proceedings are being conducted and financial penalties are being imposed. In practice, obtaining a waiver of a financial penalty from the authority in SENT proceedings is very difficult. In the case of RMPD matters, it remains a disputed issue whether the provisions governing the possibility of refraining from imposing a financial penalty can be applied at all. For this reason, it is certainly more advisable to invest at an early stage in appropriate training and in the implementation of internal procedures within the undertaking, rather than to engage in lengthy and costly disputes after financial penalties have already been imposed. Naturally, even well designed procedures and proper training cannot guarantee the complete elimination of risk. During inspections, doubts may always arise as to the interpretation of a specific factual situation or a particular provision of law. Nevertheless, such measures significantly reduce the risk of irregularities and help raise awareness of how important it is to understand obligations and to act carefully and diligently already before commencing SENT and RMPD transport operation. That's all from my side. I hope the presentation met your expectations and provided an overview of the Polish procedure before administrative authorities and administrative courts regarding monetary penalties under the SENT and RMPD systems. Thank you for your attention, and should you encounter any issues related to the system, RMPD, or SENT, please feel free to contact our law firm. Please find our email address and phone number here for any further contact.